Welcome to another episode in the series of SCC Online Interviews. I am Massoma Rizvi and I'll be your host for this episode. Today we have with us Mr. Tariq Khan, an alumnus from Jamia Millia Islamia, whose business was youngest 40 under 40 for 2020. He has also been featured in Fortune 500 magazine. Essentially, Sir practices domestic and international arbitration against Singapore International Arbitration Centre rules as well as the Indian Council of Arbitration Rules, etc. He's also a writer and a columnist, having more than 50 publications to his credit in various journals, magazines, and popular legal news portals. He's also qualified to the conference round of Judge Advocate General of the Indian Army. Without further ado, let's hear it from the man himself, Mr. Tariq Khan. Welcome, sir. I thank you for speaking with us today.
Thank you, Masooma. It's my pleasure.
Right, sir. So, my first question to you would be if you could tell us a little about why you came to choose the field that you're working in right now.
Okay. So, are you talking about law or are you talking about arbitration?
I'm talking about law and moving into arbitration.
Okay. So, law was never my first choice. I did not want to pursue law as a career because
Right.
I did not have anybody in my family who was a lawyer. I did not have influence of lawyers early in my life, and I belonged to a small town in UP
Right.
where the legal system was not something which would have been of interest to a young guy who was studying in a school. So I think at that time we were more inclined towards other professions like engineering and all, and that's why I took up science. And the other reason why I never wanted to opt for law was that I did not have command over the English language. I
Right.
was not fond of reading, and
Right.
I did lack a lot of confidence. I had stage fright, due to which I thought it would not be a great idea to go for this profession. But for some reason, I couldn't qualify the engineering exams, and my rank was terrible in AIEEE, and I had no other option but to do law. And that's how I think law chose me. I didn't choose law.
Right.
And yeah, so far as arbitration is concerned, so when we graduated, when we were about to graduate, so there were hardly any placement. I don't think there was any placement back then in my college, and we had to look for a job ourselves. And I started applying actively. And I think at that time there was some issue of the tag of the college. The tier one colleges were given preference in a lot of law firms, in the top law firms. So not many law firms were open to accepting students from tier two law colleges or probably non-national schools, if I may put it that way. So I think it was tough, and I just got an opportunity with Advani, which was essentially doing arbitration, and I did not want to miss it. So I still believe that losers are not choosers, and at that time, any opportunity was a big opportunity for me. So I did not waste or think twice, before taking up this opportunity. And I had never studied arbitration in my college life. It was never even a subject. But when I started practicing arbitration work, I started working on arbitration matters in the firm. That's when I realized that it's actually a good field, and I started enjoying working. And since then, it's become my passion, and that's what I've been pursuing.
That's very lucky for us that you're into law and into arbitration. So moving on, what do you think are the positive and negative impacts of these virtual arbitrations that have started in the wake of the COVID-19 pandemic?
So I think that I've been telling people, and a lot of my interviews I have said that we must look at it as a development in the law. Law keeps evolving from time to time, and this is like an evolution. We should not treat it as something. Virtual hearings are not something which has been imposed on us, and we are forced to do it. So I think it's a blessing in disguise if you look at it like that. Many things have changed. It has made life much easier. I know there are people who are facing difficulty. There are people who are not technically, tech savvy. They're not tech savvy. They don't know how to use these platforms. And a lot of people do not perhaps have access to internet in a lot of small districts. However, I feel that for a lot of practitioners who earlier had to fly from one city to other, Now that time has reduced, we don't have to waste a lot of our time driving to the court and then finding a parking. I think virtual hearings have made life much much easier. We are able to attend matters at the comfort of our home, at our office. Three matters, probably matters in the same day in different cities and different courts. It's now possible without any kind of physical. Uh, Earlier, there was a lot of stress, and we had to rush from one court to the other. You would just not, no time to breathe also. But I think that was a positive side. But yes, the issues are one is that I've told you that not everybody is tech savvy, and they do not have access to internet. Probably people in small towns and cities. Apart from that, the other issues that may be there with virtual hearings include when the matter is very voluminous. That is when you do not know, you don't have any assistance, and you sometimes need to refer to a lot of documents at the same time. Virtually, that may not be possible because in a physical setup, a lot of people can assist you. You can open all the documents and refer to them, multiple documents at the same time, especially in a cross examination. I think that it is required that you look at certain documents and voluminous record for asking questions and for asking follow-up questions. So I think in these kind of instances, virtual hearings may be problematic. But at the end of the day, like I said, it all depends on us. Once we get accustomed to it, of course, we will then be able to treat it as something which is a matter of practice.
So do you think this is going to continue when things go back more a little bit to the normal and when courts and arbitration centers start opening up, or do you think that this is going to be the future?
Well, I think it should continue, but
Right.
I'm not sure because a lot of lawyers recently wrote to the Honorable Chief Justice that they were not in favor of only physical. That option should be given, and I think I completely endorse that view. That option should be given. People who are comfortable appearing in court, they should be given that opportunity. But there are people who prefer being at home, especially in a pandemic situation. But I think we have learned quite a lot, and I think virtual courts are doing great. These webs apps are doing good. It's as good as a new. Initially we had difficulty, yes, because we were not prepared for it. The infrastructure was missing, but I think now that we have everything in place, I think we should continue this, and we have got accustomed to it, so it must be kept optional. But let's see how it happens once the vaccines and all everything is done and the pandemic is over. Then perhaps people will revert back to the normal life.
Right. Sir, I would also like to know your view on the recent amendment to the New Delhi International Arbitration Center Amendment Bill, which was recently passed, which is seen as another step in the direction to make India this sort of hub of arbitration.
See, you're talking about the center. I must tell you that amendments have taken place quite a lot. New legislations have come into the picture. And yes, the government and the legislature is, of course, trying its best, putting the best foot forward to make India the hub of arbitration. But the problem is that we are lacking somewhere. There are certain issues which have been missed. For instance, I don't think act is a problem. I think the honest implementation and enforcement is missing. So if you look at certain amendments, so what we do, we take 5 steps forward and then 2 steps backward. But those 2 steps will undo all the good things that we have done. Will take us back to square one. For instance, sometimes you've seen certain judgments of the court. So 6, 7 good judgments and one bad judgment will take us back to the same position. And it takes a lot of time to uh, make good the loss which is caused because of one judgment. The kind of damage that a judgment can have on the arbitration jurisprudence, for instance, we cannot even imagine. But regarding the Amendment Act, I think the things which we need to now focus on, yes, the step is positive. The government has taken a good initiative. But at the end of the day, everything will depend on how it is implemented. We must make India a country which is promoting institutional arbitration. We should do away with the practice of ad hoc arbitrations. And that's what the government is trying to do. But I think the focus should not only be on Delhi and Mumbai. That's my major complaint. Every time I keep telling this, I think we must also focus on places like Kanpur, Lucknow, Ahmedabad, and other cities which are the hub of business. If we really want to make India the hub of arbitration and not Delhi or Mumbai the hub of arbitration.
So, when we were talking about the pandemic, I was thinking if you could explain a little about the issue with limitation period of arbitration and how it was dealt with by the court with regard to the pandemic, etc.
I think there was a March, 3rd March or so, order suo motu writ petition by the Supreme Court, wherein all these limitation for all these practical purposes was extended. And I think there was a May order, wherein the Supreme Court clarified that, look, wherever the extensions are required, for instance, in 29A, etc., automatically the timelines will be extended and the timeline will get over. I think at that time, different cities had different dates for lockdown lifting. So it was as per the state that when the lockdown is lifted, 15 days from that date, the limitation will get over. So I think, yes, a lot of people did in fact get benefit. So yeah, those orders clearly record, and that's the long and short of it. Because at that time, frankly, a lot of, but now everything I think is back to normal. No more that benefit is being stretched beyond a limited point because the courts have now opened up almost physically, like fully.
Right. Yes, moving on, I would like to ask you that as a faculty member for arbitration, what advice would you give to law students who are interested in arbitration? And along with that, how do you think law students should equip themselves with legal research skills?
So I mean, I think it's actually a great feeling being a teacher, and I've been teaching for almost 6 years now as a guest faculty. I've taught in some of the prominent law schools. I've taught at Indian Law Institute. I've taught at Lloyd Law College. I've taught and now I'm currently teaching at a National Institute of Finance Management. I mean, I think it's actually a great platform to probably sharpen your skills. And, being a teacher, it does clear your mind and make, clarify your concepts. A lot of, as a practitioner, there are things which when I don't get into the how of things, why of things, and what of things. But as an academician, sometimes in the class, the discussions are very interesting. And some of the most brilliant young minds, I interact with them. I am, when I'm discussing a problem with them, so they put up certain questions which makes me think and wonder. And that's when I'm forced to go to the how and why of arbitration. And I think that is a very good thing. And that's why I keep myself updated with the latest developments in the law. And I think it has helped me in all aspects. And I think students must focus on research. Research is a trait which any good lawyer should have, whether you are practicing or not, whether you're sitting in the comfort of an office, but whatever option you choose as a lawyer, in-house, corporate lawyer, research is something which will always be required, and I think it will be an add-on. It will be an advantage on your side. So yeah, research skills are to be, but I think it all depends on how you use the channels, how much you read. I remember Mr. Ram Jethmalani used to say that nowadays students are just about control F, and they don't really read the books. The books are there in the library, and they just feel that they're very smart. But the problem is that the kind of research that they're doing, they don't go through the judgments. I think that's a very big turn off. You need to read the judgment. Sometimes they will bring a judgment according to them, it is relevant. But at the end, it was just they will realize the judgment was held against the point which was discussed. They just control F, I think, is the worst thing that you can do. If you're reading a judgment, you read it fully in true sense and then try to make sense out of it. And I think in a book, if you use the traditional method, you will be able to find 100 judgments within no time. But the idea is that you should know how to do the proper research. So I think books are still the best friend of a lawyer. You only need to know how to use it. Softwares and all are fine, I mean, for quick research, but at the end of the day, you also need to have that kind of knowledge. The idea is not to just give a judgment, but to also be updated and have some knowledge about the subject, which will happen only when you read full judgments.
Right, understandable. And how, like you said, that it's very important to stay updated. That would include reading recent judgments and sort of keeping up with the news of what is happening in that area of law that you're interested in, if I understand correctly.
Yes, I think that's very important, Masuma, because I mean, speaking for myself, I have been reading almost every judgment which is pronounced by the courts across the country. Because if I say that I'm an arbitration practitioner, I think to be able to do justice to this title, if I'm saying I specialize in arbitration, so far as arbitration is concerned, I think I need to know what are the developments in law. I need to know what judgments have been passed. Yesterday, the law was different. Today, it is not the same. It may have been overruled. Probably it is being discussed. So I need to know what cases are going on in the country. Supreme Court is referring issues to larger bench. So I need to be updated because sometimes, the clients may ask you, what is the position of law? And you can't really give them an incorrect position. And that's why, even when I'm teaching and when I'm giving lectures in a webinar, questions are put to me. And if I'm not updated, then how do I address them? I can't be giving incorrect answers, no? So it helps you, and even the judge sometimes asks you about the latest position of law. And as an officer of the court, it's the duty of a lawyer to be updated and to give the correct information and not just mislead the court.
Yes, definitely, sir. So, in addition to being a lecturer, you also have more than 50 publications to your credit. In that context, how has doing proper legal research, if I may put it that way, how has it helped you? And what do you think exhaustion of research means to you?
Basically, see, I think writing does help quite a lot.
Mhm.
And it's something which, increases your visibility, and you are able to reach so many people at the same time. But I think I need to give an advice to the students that the idea is not to publish anything. Quality matters, quantity doesn't matter. I've seen a lot of students recently, they've been writing so many articles and they think that the idea is to do justice to one article. That, if I read it, the quality should be such that I'm forced to read the other article. And then I start thinking that this person writes well. So writing is not important. What you write, the content quality should be next level. Your views, your thoughts about the subject should be, uh, you know, uh, worth reading, and people should actually, it should interest people. And that's when they actually say that, this person writes pretty well. And people then say that his pieces are really impressive, or her pieces are very impressive. And I think research, of course, like I said, you have to be updated, and developments, only if you know, then you'll be able to write. Because if you do not know what's happening, it cannot be that something which happened last year, you are writing about it right now. And the best thing to do is to write about those topics which are current and which are, in the news, when people are interested in reading about it, because they want to know how this case is going to impact their ongoing cases. This development will affect it or not. So I think that's the reason, when people should really research pretty well. If you are writing an article and if you're not properly researching for it, giving an incorrect position of the law, I think that's the worst thing you can do. That's pretty embarrassing. Somebody points it out that, look, you haven't really included the landmark judgment, or you haven't really put the correct perspective. So I think, yeah, these things are important, and research should be like very important. And I think a well-researched article, anybody would take at least 2 weeks to write a good article. But I've seen people trying to finish articles in just 2 hours, 3 hours. So copy pasting will not help. Your concept should be clear, and when you're writing something, you actually need to know everything about it. So if you have read 500 pages, then perhaps you'll be able to write 5 pages about it.
Makes sense. So, and like I said, when would you say, is there anything like when research is exhausted, where you would say, I don't need to research on this point anymore? Do you think it's humanly possible to reach that point?
See, I think that many of my interns have told me, sir, I could not find anything on this. I tell them there's never nothing. There's always something.
Right.
And the beauty about research is to find something when there is nothing which is existing and clearly visible. So that's the beauty about a good researcher. So it's not the case that merely because you can't find it, it doesn't exist. At times, I had given research to some of my students. They took like weeks and didn't give me anything. And I made them sit in front of me and I said, look, in 5 minutes, I'll give you a case. And I did. So I think a lot depends on the search queries that you are putting, how nicely you have understood the uh, question of law, what you're researching, what is your ultimate aim, what are you trying to look for. If you don't find anything directly, try to look for something which is indirect. But ultimately, you need to form synonyms in your mind. You need to see what kind of search queries can I put, which will eventually take me to that judgment. You have to think like a judge sometimes, that what the judge would have written in the judgment that I should type so that I reach that particular judgment which I am seeking. So, that's how you have to find. You have to imagine certain phrases and expressions which may have been used in a judgment. And yes, I mean, I mean, sometimes people get tired. So if someone cannot find something, then I keep telling them that, look, if you are good at research, you'll find something in the next few hours. If you are taking days to read about it, you're just doing an academic exercise by getting to know about the subject, and you will not find anything. So if there is something, and if you are really good at it, which of course is always is, there's always something. But if you're not able to find it, then probably you are either not doing it nicely, or you're just not interested in research, you're just trying to Google and, you want something to Google to spoon feed you. So yeah, I don't think people can say that I'm exhausted and I can't really find anything beyond this.
That makes sense, sir. So with that, I would like to wrap up this interview, and I would tell you that I've learned a lot by speaking with you as a student and as with speaking to you as a lawyer. So I really, really thank you for taking out the time, and I hope we speak with you again. Thank you for your continued collaboration with SCC and EBC.
Thank you so much, Masooma. Thank you for your time. It was really nice speaking to you. Thank you very much.